Tonight on the Daily Debrief, the case of the so-called Hollywood Ripper.
The boy next door killer. That's what this case is about.
How prosecutors say he attacked a woman who survived, and how the defense is blaming other associates of the victims.
She was physically abused for 9 years.
Plus, a ruling to throw evidence out of court in another Florida prostitution sting may affect the case against Robert Kraft. And can you name the Chief Justice of the Supreme Court? A lot of people could not. A new survey sheds light on our country's own perception of its justice system. This is the Daily Debrief. It's Friday, May 3rd.
Good evening, everybody. Welcome to the Debrief. Michael Bryant, Jonna Spielberg here along with me tonight. We have another guest, Joseph Tully, who will be joining us in just a moment. Opening statements are complete in the trial of a suspected serial killer. It's being called the case of the Hollywood Ripper. Michael Gargiulo is accused of killing 22-year-old Ashley Ellerin in 2001 and 32-year-old Maria Bruno in 2005. He's also accused of attempting to kill Michelle Murphy in 2008. Those are just the victims in this case. Ellerin was said to have been waiting for a date with actor Ashton Kutcher when she was stabbed to death in her Hollywood apartment. When he came to pick her up, she did not answer the door. Kutcher is expected to be a witness in this case. Keep in mind, this defendant is accused of killing another woman in Illinois before he moved to California. During opening statements, the prosecutor played two 911 calls in the case of surviving victim Michelle Murphy. The first was from a friend who reported that Michelle woke up to find someone on top of her stabbing her. The second is this call. It was from 911 to Murphy herself.
Hello? Hi, this is the San Monica Police Department. Are you calling from 1229 12th Street?
Yes.
Okay, what is your name?
Michelle.
Michelle, what happened? Where's that person now? How long ago?
Not more than 7 or 8 minutes ago. I don't know. I'm late and
The fire department is already on the way and we're on our way. What does this person look like?
I only know his name is Paul, and I can do it. I just
Was he white, black, Hispanic, Asian?
I don't know.
Do you remember what his clothing was, what he was wearing?
He definitely had on pants and like a long sleeve, like sweatshirt kind of thing.
Do you remember what color the sweatshirt was?
Everything's dark. It's all no.
Okay, do you remember what color pants?
No.
Okay, did he, besides stabbing you, did he hurt you in any other way?
No.
Okay, the fire department is on our way and we are already there. We're looking for the guy now. We'll be making contact with you in just a second. Do you remember how big this guy was? How tall he was?
He was probably maybe the most, I don't know, like 5'11" or something.
Thin, medium, or heavy? And do you remember his hair? He broke into your window?
He broke the screen.
Okay. Do you remember his hair color, Michelle?
No, I didn't see any of that.
Do you remember if he was wearing any type of headgear, like a hat or anything like that?
No, I don't think he was that kind of a boy.
Do you remember any scars, marks, or tattoos or anything like that? No? Okay, so was he armed with just the knife? Michelle, I'm sorry, I'm here with you. Can you walk to the door? Are you able to walk to the door?
What?
Are you able to walk to the door, Michelle? Because the police are there. We're here with you, okay?
Is that you?
Yes, we're here with you now. So go open the door for me, okay?
Even though the words were hard to make out in places, the fear was still evident in the tone. Here is how the prosecutor began to connect this defendant to that attack.
This is the front of Ms. Murphy's apartment with one of the Santa Monica police cars parked out in front. This is Ms. Murphy's apartment. To get into the apartment, you go down this walkway that I'm indicating on the left-hand side. This is an aerial view now of Ms. Murphy's residence as it relates to the proximity with Mr. Gargiulo's residence. And again, ladies and gentlemen of the jury, you will have the opportunity to go out there and actually stand in this alley between the two apartments, and you'll see it with your own eyes. So So on the left-hand side, we have Michelle Murphy's apartment, which is at 1229 12th Street, apartment number 10, that I'm indicating now. And right across the alley is Mr. Gargiulo's apartment at 1232 Euclid Street, apartment number 10. And that's a stone's throw away, approximately 100 feet. And as I indicated earlier, Mr. Gargiulo's apartment, which is on the second level, you can look out his living room window, you can look out his kitchen window, and you can look out his side office window right into Michelle Murphy's apartment. This is a view down the alley that was taken during the night of the attack. On the left-hand side, you'll see Ms. Murphy's balcony in the red circle. These are detectives. That's a detective on the left and a criminalist you're seeing there with the surgical mask on. On the right-hand side of the alley is one of Mr. Gargiulo's vans.
Murphy was exercising in that alleyway just hours before she was attacked. She left her window open, and prosecutors say the defendant saw that. At least that's what they theorize. And they say the defendant climbed up onto that ledge you saw, cut open Murphy's screen, and attacked Murphy at 1:45 midnight. Here's the rest of the state's theory of that attack.
This is the crime scene. What you're looking at here, ladies and gentlemen, is Ms. Murphy's bedroom. On the left-hand side, you can see her comforter that's covered in blood that's on the floor, and that is her bed in the background. On the right-hand side, you're basically seeing the same view that's a close-up of her, more of a close-up of her bed. And what you will hear from Ms. Murphy, I believe, is that she was sleeping on her back, and that's when Mr. Gargiulo came in and put one knee on her bed, and then with his left hand started stabbing. This is a close-up of Ms. Murphy's bed. You can see the blood spatter all over the walls and all over her sheets and pillowcases. This is another angle of her bed and a reverse angle that shows her bed and the comforter as it exits her bedroom. These are additional photographs of her bloody sheets and her bed and her pillows. Again, photographs of blood on her sheets. That's her fitted sheet. This is a close-up of her pillow and her fitted sheet again. Here's the comforter that now has been tossed onto the floor in the struggle and is on the bed, on the floor in the doorway leading out toward the hallway and her bathroom.
The prosecutor says Gargiulo's DNA is on Murphy's comforter, plus there's a trail of the victim's DNA and the defendant's DNA leading out of the victim's apartment. The defense has a different theory. The defense said there's no physical evidence tying their client, at least to Ashley Ellerin's murder, and they brought up the possibility of other suspects.
You're going to learn in this trial that there were 4 people who had keys to the residence of Ashley Ellerin. Obviously, Ashley had a key to her house. Her roommate at the time, Jennifer DeSisto, had a key to the residence. There was a friend of hers and a former roommate, a gentleman by the name of Justin Peterson. He was a friend, and he had roomed with Ashley at the Hollywood residence and later on moved out, but he still had a key. And then lastly, and I think significantly, the apartment, or I should say the building manager, a man by the name of Mark Durbin. Mark Durbin. I think he's going to be an important witness for you to focus on as it relates to the homicide of Miss Durbin.
The defense tactic here is to raise reasonable doubt. What else? Jurors will have to decide if it's going to work. As to the murder of Maria Bruno, the defense also raised alternate suspects.
A little history regarding the dynamics of Maria Bruno and her husband, Irving Bruno. Maria Bruno left her husband, Irving, I believe it was in late October, possibly sometime in November, because she was physically abused for 9 years during their relationship. In fact, it was December the 3rd, 2 days after Maria Bruno was murdered. Her husband, Irving Bruno, was being interrogated extensively by sheriff detectives. And during that couple hours of interrogation, Irving Bruno admitted that he had pushed his wife, threw her to the ground, punched her in the face, blackened her eyes, and these were his words. His wife, Maria, said, that was a straw that broke the camel's back.
Okay, so what do we have here? Alternate suspects or clear-cut evidence against this defendant? Attorneys Jonas Spielberg, Michael Bryant, and Joseph Tully are with me tonight. So let me start with you on this one, Joseph. Is this a strong case for the prosecution or what? I think it's pretty strong. What do you think?
I think it's an exceptionally strong case for the prosecution. I think, let me give what's going to be a big trouble for the defense attorney is 4 numbers in a letter, 1101B evidence. So in other words, just because somebody's done something before, you can't bring that into court. However, what the prosecution is hammering the defense with during opening statement is the fact that this defendant does have the same pattern and practice with regard to multiple different circumstances, and that is allowable in court.
Oh, yeah. Okay. So I always sit here and wonder about this. I know the rules. The rest of the panel knows the rules. Whenever you can bring in all these other bad acts and throw everything together, it makes it an uphill battle for the defense. But, Michael, the defense is really trying to knock these charges out one at a time. That's how defense works.
Well, I think they have to. If you look at the dates of each of these crimes, it wasn't like they took place on the same day, week, month, not even the same year. In California, 01, 05, 08, you've got to attack them as separate individual crimes.
Certainly. Okay, Jonas Spielberg, brutal stuff in this case. This is sick. This is sadistic. The cuts and some of the pictures that were shown during those opening statements, this was calculated, at least it seems, to inflict some really serious pain.
Not only that, not only was it calculated to inflict pain, he ambushed his victims most of the time, which makes it even worse. And if he is the culprit, and we're assuming that he is, he's not a small guy. And his victims are always female. So this was calculated. He knew what he was doing. And if he's guilty, he is a brutal killer. Okay, let it be known right here. Jonas Spielberg just flipped the burden of proof on the debrief. I don't know about that. I mean, you're falling into the prosecution theory here. But look, this is a strong case. Unfortunately, we can't show the rest of it. We can only televise the opening statements, the closing arguments, and the verdict. So we are going to keep an eye on it, but that is all we can show you in this case for now. And testimony is on hold yet again in the case of the McStay family murders in California. Defendant Charles Merritt there is accused of killing business associate Joseph McStay and the entire McStay family. The family disappeared in 2010. 3 years later, the graves of all 4 of the McStays turned up in the desert. The defense is trying to convince the jury that another business associate, Dan Kavanaugh, is the one who's really behind the crimes. And now for some insight into the legal knowledge of the average American. And look, most of the time, juries work very, very hard to get things right. Most of the time, experienced courtroom professionals agree that juries do that. But sometimes we see very strange verdicts and wonder what exactly is going on. A new survey might enlighten us.
An American Bar Association survey of 1,000 Americans this week sheds light on what Americans think our laws actually say. According to the survey, 1 in 10 Americans think the Declaration of Independence freed the slaves. It really declared our independence from the King of England. 1 in 5 think the first 10 amendments to the Constitution are in the Declaration of Independence. Wrong. The amendments are in the Bill of Rights. Less than half of those surveyed knew that John Roberts is the Chief Justice of the Supreme Court. About a quarter thought Ruth Bader Ginsburg was the Chief Justice, and 16% thought Clarence Thomas was in charge. When it comes to actual constitutional law, 30% said people who are not citizens have no right to free speech. That is wrong. 15% think the government can refuse due process rights for non-citizens. That is also wrong. 11% think the government should be able to prevent the press from covering political protests. 54% said flag burning was illegal. 11% thought the government could censor news reports before broadcast or publication. On all of these questions, the First Amendment says otherwise, but maybe survey takers have never even read it, because 20% said the freedom of press is not in the First Amendment. Of course it is. But maybe there is hope. 95% knew that the Supreme Court is the nation's highest court, but then again, the name sort of gives that away. The ABA survey questions came from a pool of questions used in naturalization tests for new citizens. Only 5% of Americans aced the survey.
That's a look at what Americans are thinking right now. Still ahead tonight on the Daily Debrief, the case against an NFL owner accused of soliciting prostitution. Robert Kraft's attorneys want a judge to throw out a video recording of Kraft allegedly receiving sexual stimulation for money. We break down a troublesome ruling for the state after the break. Welcome back to the Debrief. A Florida judge is now deciding whether authorities there broke the law when they installed cameras inside a massage parlor as part of a prostitution investigation, which of course netted the arrest of an NFL owner. Detectives say the recordings show New England Patriots owner Robert Kraft and others receiving illicit sexual massages. Kraft has pleaded not guilty to charges that he solicited prostitution, and his attorneys argue that the recordings were unconstitutionally gathered and must therefore be thrown out of court, even though the detectives had a warrant. The Kraft decision might be influenced by a different but similar case in another Florida county. In that other case, a judge just this week suppressed similar undercover massage parlor recordings. The judge in the similar case ruled that there was no Florida law on point, but that federal law from another circuit required police to minimize their invasion of privacy when installing cameras in private massage rooms. Instead, the police in this other case recorded multiple cameras in multiple rooms for between 2 and 4 weeks. The judge said the blanket storing of all surveillance of all rooms at all times was illegal. Finally, the original warrant in this other case authorized monitoring, not recording. And though the judge suggested the police might have been, quote, insidious in their failure to understand the difference, he did not factor that distinction into his immediate ruling. So that was the decision in another case, but the attorneys representing Robert Kraft say, guess what? His case contains the same flaws.
The warrant itself has no minimization instructions in it. It simply says don't look for sexual or non-sexual activity. We heard from witnesses today that there was no written requirements, there was no oral requirements. We heard from the second witness that she heard about minimization from her husband. She'd never minimized before. She had no instructions on how to minimize. The prior witness said, you know, no one told me what to do. I just sort of made my own decisions as I went. We saw as we went through the evidence on what they actually saw, that they were making their own decisions about what to look at and what not to look at. Judge, regardless of whether or not that is, you know, they were trying to, I think they said, which I have no reason to dispute, they were trying to maintain the dignity and respect and concern for the dignity and respect of these people. The fact is that's not what the Constitution requires in any part of this country, under Florida law, U.S. Supreme Court law, of any state. The requirement is that the instructions on minimization have to be put in the affidavit and or the warrant. It has to be very clear and set out and explain what it is you do to prevent innocent people or innocent conduct from being captured on this very intrusive method of investigation.
Prosecution told the judge there was a big difference between the Kraft case and the other case in the other county where the recordings were thrown out. The other county's recordings went on for possibly 4 weeks. The recordings in the Kraft case lasted 4.5 days.
You need to know, Judge, that judge, first of all, how long was their recording?
30 days.
Their recording was for 30 days. And without making a comment on that, for whatever it's worth to the judge, for whatever weight you give it, Judge, we were 4.5 days?
Correct.
We were 4.5 days, Judge. And actually, to be honest with you, we were called, and I'm not blaming Jupiter, because officers want as much evidence as they can get. They called us on the phone. They told us what we had. We said, shut it down. because 4.5 days was plenty. We had the evidence. We identified everybody in there. But for the defense to stand up here and talk about the Martin County case and not tell Your Honor that one of the main reasons why that was suppressed is because it was unfettered recording of innocent people. And I think they had somewhere 25 or 30 different people with legitimate massage. Unfettered, Judge, just recorded, just carte blanche. Was the defense ever able to prove that there was no meeting? It's their burden that there was no meeting about that. No, they didn't prove that. All they proved is the two detectives that I called to the stand, and admittedly so, were not instructed.
Okay, back to our panel for this one now. We're going to fight this one out until we run out the broadcast here. Joseph Tully, is this an argument about time, or is this an argument about hitting the stop button when there are innocent people getting legitimate massages? Because I don't know if the time argument wins this case for the state.
I would agree with you. I don't think that if a wrong is done, if it was done 30 days in a row versus 6 days in a row versus 3 days in a row, it doesn't matter to a legal analysis. I think what should be pointed out, though, is suppression motions are very hard to win. Mr. Kraft, in general, would have a better chance of winning a game on an onside kick with 1 second left on the clock. Judges hate granting these motions.
Well, that's a good analogy. I'm glad you thought that one up because, look, you know, Jonah, this judge in this other county says, okay, throw him out. So he kind of threw out the premise that Joseph brought up there and said, well, I will toss these things. But he's importing law from another federal circuit into Florida. And I get there's persuasive law, but could somebody else look at this and say, no, I'm not going to do that?
Well, could that happen? Yes. Should it happen? No. This current judge should take a real cue from the judge who ended up throwing out the evidence and suppressing under the same facts and circumstances. I agree with Joseph. It doesn't matter whether it happened in 4.5 minutes, 4.5 days, or 4.5 weeks. Once the Fourth Amendment has been violated, it's been violated, period. And I think it was clearly violated in this case.
Okay, you know, we heard the detective there, Michael, saying, oh, yeah, I knew very quickly whether or not this was going to be an illicit massage or whether it was going to be a legitimate massage. Where was the stop button? I think that's what dictates the analysis here.
You know, this was the underwear rule. You know, they had some clues they felt were valid to determine whether illegal activity was going to take place. Underwear on, maybe not. Underwear off, definitely. And I just think those kinds of assumptions are ridiculous. And then how do you hit the stop button? And if you slop over into some innocent activity, how do you unsee that for purposes of a search and seizure?
You know, unsee it, stop recording, something like that. Okay, we had a little gridiron battle of our own here on the Debrief. We hope that you enjoyed it, and we hope you'll join us again Monday at 5 o'clock Eastern right here on the Law and Crime Network. Have a good weekend.